Good day to you and welcome to another Paddocks Club video tutorial. Today we'll be talking about improvements to common property. More specifically, I will discuss how to distinguish between reasonably necessary and not reasonably necessary improvements to common property. You may ask why the distinction is important. The simple answer is that each type of improvement requires a different level of consent. Not reasonably necessary improvements to common property require much higher consent levels than reasonably necessary improvements, which can potentially be effected by the trustees without any active owner consent. Previously, PMR 33, Subrule 1 and 2 contained in Annexure 8 of the regulations to the Sectional Titles Act distinguished between those improvements to common property that were considered luxurious and those that were non-luxurious. In this regard, neither the Sectional Titles Act nor the rules define the term luxurious, nor did either of them provide any guidelines as to what type of improvements to common property were considered to be luxurious or non-luxurious. In this regard, Professor Sergio van der Merwe has suggested that any proposed improvement that is useful and necessary is non-luxurious, and any improvement that is desirable but not necessary is luxurious. The new prescribed management rules contained in Annexure 1 to the regulations to the Sectional Title Schemes Management Act have incorporated this principle of necessity into the determination. Now, PMR 29 Subrule 1 provides that the body corporate may, on the authority of a unanimous resolution of the members, make alterations or improvements to the common property that are not reasonably necessary. PMR 29 Subrule 2 provides that the body corporate may propose to make alterations or improvements to the common property that are reasonably necessary. Practically, it would be the trustees who would initiate this process, and the rule sets out the steps to be followed by the trustees, including notifying the members of the proposed improvement and the effect thereof. The notification should include the estimated cost and how it will be met, as well as a motivation including drawings or diagrams for the proposed improvement. The rule provides that if any of the members request a general meeting within the 30 days notice period, then the proposed improvement can only be authorized by special resolution. Neither the Sectional Title Schemes Management Act nor the rules define the terms reasonably necessary or not reasonably necessary, or provide any guidelines as to what type of improvements to common property are to be considered reasonably necessary or not. Ultimately, the answer to whether the improvement is necessary and useful will depend on the person answering the question. The question will always be subjective and will have to be determined on the particular circumstances of the scheme. In this context, circumstances would include the location of the scheme, its existing amenities, its financial well-being, and the needs and desires of the current body of owners. For example, the owners of a 3-story building in an affluent beachfront scheme may believe that a lift is necessary and useful and not merely desirable, whilst the sectional owners of a 3-story building in a less affluent area may agree that it is merely desirable and not necessary. Subjectivity and value judgment definitely play a part in determining the answer. The same owners in the ocean-facing scheme located in a holiday hotspot may see the addition of a swimming pool, gym, or recreation facility as reasonably necessary and useful. Similarly, the installation of security upgrades, such as electric fencing or CCTV, may be seen as reasonably necessary, while the installation of voice or fingerprint recognition security and access devices may be seen as merely desirable. If the trustees who usually initiate any improvement process feel that there will be disagreement or dissension amongst the owners as to whether the improvement will be reasonably necessary or not, we recommend that they call a general meeting of members and ask for direction from the body corporate as to how to classify the improvement, thereby instructing the trustees which process and the authorizations that will be required. A direction can be given by a simple majority of owners forming a quorum at a properly convened general meeting. Thank you for watching this video. I hope that you have found this information useful. If you have any questions on this topic, please place them on the discussion forum.